Today we are going to talk about the Latin expression de minimis, which refers to an amount that is small enough to be ignored. It's too unimportant or small to be taken seriously. The expression is short for the Latin phrase de minimis non curat lex, meaning that the law does not care about insignificant or trifling matters. This is known as the de minimis doctrine. We often see this phrase in the following context. For instance, in the sentence de minimis, claims below £20,000 are excluded under the agreement. We hear about the de minimis costs, de minimis risks, de minimis regulatory exceptions, and we even have the de minimis defense, which is part of the criminal law. In the state of Hawaii, among others, for instance, courts may dismiss de minimis infractions of the law where a defendant's conduct was too trivial to warrant a conviction, and this is what's known as the de minimis defense. Continuous, continual, continuance, continuing, shareholder. We are going to talk about two words that are used quite often by lawyers. Many times they are treated as interchangeable, however they are not, and they are continuous and continual. You will see these words whenever the passage of time is involved in legal documents. For example, you might see them in contracts of employment or loan documentation. So, what is the difference between these two words? Well, continuous means occurring without interruption. Continually means frequently recurring. So some examples are in order here perhaps. So you might see continuous in the following sentence. The employment must be continuous for the employee to be eligible for the benefit. Or continual, you might see them in a sentence like this. There shall be a continual duty to pay the supplier following delivery. Many times lawyers will use on a regular basis or regular instead of continual. Lawyers will use on a regular basis or regular instead of continual. And finally, you will usually see these terms in their adverbial form continuously or continually. Thank you. Hello. Today we are going to be talking about common law and equity. These are two terms that are often confused, and it's easy to see why people confuse them. The term common law is confusing as it has different meanings depending on the context. So it could be used to refer to law crafted by judges when they decide cases. This is what we refer to as case law, and this is in contrast to law established by legislation. By the legislature enacting legislation, also known as statutory law. It can also be used to refer to law that is not equity. And finally, it can be used to describe the law of countries which follow the common law, like the United States and England, as opposed to countries that follow Roman law or French law or the civil law tradition. In this case, it means that the entirety of the law, including legislation, case law, and equity. So then, what is equity? Well, equity is the name that we give to the set of rules that traditionally supplemented the common law, where the application of the common law would have operated too harshly. This was done to achieve what is sometimes referred to as natural justice, so more simply speaking, fairness. Today, equity has merged with the common law to become a branch of the law dealing with, among other things, trusts and certain remedies such as injunctions. Legal disputes. How are legal disputes resolved? Most legal disputes are resolved through an out-of-court settlement between the parties. However, if the disputing parties are unable to reach agreement, there are a number of options available. The traditional choice is litigation, with the case ultimately being tried in court and decided by a judge and/or a jury. Besides litigation, various forms of alternative dispute resolution (ADR) are also available. A barrister and solicitors, and please remember the correct pronunciation of solicitor. In the United Kingdom, the legal profession is divided into two kinds of lawyers: solicitors, who generally advise clients and prepare legal documents, and barristers, called advocates in Scotland, who argue cases in court. In cases where a trial is necessary, a client has to hire a solicitor who will advise them and then retain a barrister on their behalf. Solicitors have traditionally dealt with any legal matter other than conducting proceedings in court, although nowadays solicitors may appear in the lower courts and also if they have a higher rights of audience, i.e., the right to appear in court on behalf of another person in the higher court. Barristers, who have a general right of audience in all courts, represent clients in court and provide specialist advice on complex legal matters. The easiest way to distinguish the two is to look at how they dress. Barristers are the ones wearing wigs and gowns, yes, even in the 21st century, while solicitors will invariably be decked out in a dark suit. Thank you.